Hello everyone, my name is James Collins and I'm the president of the Indiana University Federalist Society chapter. Federalist Society is a nationwide network of law students, lawyers, judges, and scholars who believe that individual citizens can make the best choices for themselves in society. We were founded in 1982 by a group of law students interested in making sure that the principles of limited government embodied in our Constitution receive a fair hearing. Our mission is to provide a forum for legal experts of opposing views to interact with members of the legal profession, the judiciary, law students, and academics. I'm honored today to present Professor Lee Strang of the University of Toledo. Professor Strang is the John W. Stepler Professor of Law and Values and is a graduate of the University of Iowa Law School. After graduating, he clerked for Judge Alice M. Batchelder on the Sixth Circuit Court of Appeals. As an academic, he's published dozens of articles on constitutional law and interpretation, property law, as well as religion and the First Amendment. The source of today's talk is Professor Strang's recently published book, Originalism's Promise, a natural law account of the American Constitution. In it, he makes a novel case that fidelity to the original meaning of the constitutional text is required by both law and morality. In addition to Professor Strang, as you can see, we are pleased to have our own Professor Steve Sanders here, joining us to give his thoughts on the book. Professor Sanders received his JD from the University of Michigan and clerked for the Honorable Terrence Evans of the Seventh Circuit, and he also practiced with the Supreme Court and Appellate Litigation Group at Mayor Brown in Chicago. You guys have probably all heard this, but it's always fun to tout on Professor Sanders because he's worth it. Taught at University of Chicago and Michigan Law, and he currently teaches con law here and has written more articles than I care to count about constitutional interpretation and the 14th Amendment. And with that, I will turn it over to Professor Strang to begin his presentation.
Good afternoon. Thank you so much, James, for introducing me, and thank you, Charlie, for inviting me down here. It's the first time I've been on the campus, first time I've been to Bloomington. It's a beautiful city, beautiful campus, and a beautiful law school. And thanks, of course, Professor Sanders for commenting today. Professor Sanders is a great colleague, an excellent scholar. We've known each other for a number of years. I've read his scholarship. I've always learned from it. And in particular, I've always learned from the way in which Professor Sanders presents his arguments. They're powerful arguments, but they're presented in a thoughtful and reasoned way. And I'm looking forward to your comments today to help me improve my own arguments as time goes on. So let me begin my remarks with what may seem to be a topic unrelated to my remarks today. So how many of you experienced this? You're in a traffic jam. It's a four-lane divided highway. A driver pulls onto the shoulder and starts to speed past you and everybody else. How did you feel when you saw the driver in your passenger mirror coming up and then passing you? What did you think of that driver? What did you say about that driver? So if you're like me, you may have had some choice words under your breath. In fact, I brought one of my children today, and that didn't happen today, but actually it literally did happen on another event where I was driving to give a similar talk, and I had one of my kids in my car, and then somebody passed me on the right, and I was going to say something, but I held back. Now, what do you think if you drive a little bit further and you see that a police officer has pulled over and ticketed that aggressive driver? Again, if you're like me, you may think the aggressive driver got his just desserts. But why is that? There's nothing inherently unethical about driving on a patch of pavement on a side of a road to reach one's destination. And in fact, our aggressive driver could argue that he's not harming anybody and he's getting to his destination earlier. So there's no loss and there's a win in this situation. And my argument today is that this aggressive driver did in fact act unethically. And you're right to be angry at him because he broke the law. And in doing so, the aggressive driver harmed both himself, he was indeed making himself into an a-hole, and his fellow citizens. He took for himself an opportunity that the legal system had not allocated to him, but instead had allocated to emergency vehicles. So how does that relate to the Constitution, you might ask? My argument this afternoon is that just like this aggressive driver, federal judges have sound reasons to follow the Constitution's original meaning. And if they don't, in other words, if they're like our aggressive driver, then they harm both themselves and our legal system. So my remarks this afternoon are based on my book, Originalism Promise. I'll speak for about 25 minutes. There are a lot of things that I can't say that I'm looking forward to your questions and comments as a way to be able to flesh out some of the implications of my arguments. And I'm looking forward to Professor Sanders' comments as well to hopefully flesh out some of those implications. There's a handout. It's what I call a simplified originalist decision tree. It's the method, it's the approach that judges should take when they're answering cases that come before them. I'll refer to it a couple of times in my talk today. And for more writings on originalism that are focused on particular topics like stare decisis or originalism and change, please go to my faculty webpage where I've posted a whole bunch of downloadable articles. So thinking about originalism, this is really the best time, at least since the New Deal and maybe earlier, to be an originalist because of originalism's legal, political, and cultural influence. And just to give you 2 data points. So one data point was during then nominee Elena Kagan's confirmation hearings, one of her remarks was, quote, "We're all originalists now." But during the Gorsuch confirmation hearings, I was teaching constitutional law, always following the confirmation hearings to see if anything was said that was relevant to what was going on in constitutional law class. And I came upon Cosmo. I don't normally read Cosmo, but I thought, if Cosmo is talking about originalism, you've come a long way, baby. And so originalism is something that's definitely relevant today in a way it hadn't been even 10 years ago. I'm going to make 3 moves this afternoon. First, I'm going to briefly explain what originalism is, how you do it, and then preliminary offer 3 reasons as to why one should do originalism. Second, I'll describe the natural law tradition and its 2 key facets of natural law and virtue ethics. Third, I'll argue that the natural law tradition leads to the conclusion that originalism is the correct theory of interpretation for our written Constitution. First, the natural law requires positive law to secure the common good of American society and individual human flourishing. And the written Constitution is our society's positive law means to secure the common good. And originalism is the Constitution's meaning that enables the Constitution to perform that central function. Second, virtue ethics helps originalist judges do their jobs well. In other words, remain faithful to the law and remain faithful to the Constitution. So first, what is originalism? Originalism arose in the early 1970s in responses to the excesses of the Warren and Burger courts. Many cases that you read in your constitutional law casebooks or maybe in criminal procedure like Miranda versus Arizona, originalists were a response to some of those cases. And Judge Bork, pictured here, was a key figure in originalism's early version. Originalism has grown in influence and sophistication over the last 5 decades. And today, the picture I'm trying to present is of a dynamic theory that responds to reasonable criticisms so that today it's one of the main theories of interpretation in the United States. On the bench, of course, Justice Scalia of recent memory. Justice Thomas, I think, is the most articulate originalist on the court. Justice Gorsuch seems to be generally following originalism. Justice Kavanaugh, Justice Alito, Chief Justice Roberts, sometimes yes, sometimes no. In the legal academy, I think it's fair to say there's been a flourishing of originalist scholarship over the last 20 years. And I'm happy to point you to books or articles written by scholars that are evidence of that. So how do we do originalism? From a 10,000-foot level, originalism is the idea that the public meaning of the text of the Constitution, when it was ratified, is its authoritative meaning. And so this means that we engage in a historical inquiry to find the public meaning at the time of ratification. Now let's say that we're trying to find out what was the original meaning of the word religion in the First Amendment. The first place an originalist will look would be the text of the Constitution and see that the word religion appears in 2 places, in the First Amendment and also in the Religious Test Clause. And there's a phenomenon of linguistic continuity where we would read the Constitution and see that it is an English document from an English-speaking culture, and the phenomenon of linguistic continuity would mean that the meaning in 1791 would continue to the meaning today. But there's also a phenomenon of linguistic discontinuity, that natural languages change their meaning over time. So the text can't be where we stop. We have to go on to find the meaning at the time. Second, we look at structure. We see that in both places where the word religion appears, it's as a limit on government. That gives us some more information. It tells us that religion is a phenomenon that government likes to be involved in, and it also tells us that the American people made at least 2 decisions as ways to limit government's involvement with the phenomenon of religion, but that still doesn't give us enough information to answer most questions in most cases. Third, we look at the framing and ratification debates. Now, the ideal would be if the framers and ratifiers had said, by religion I mean, and then gave a definition. But they haven't. I've looked for it. And we shouldn't be surprised by that because the framers and ratifiers were natural language speakers, and we don't define the terms that we use. Instead, we rely on publicly available conventions. And so what the originalists will do is look at every time the word religion appears in the framing and ratification debates, find out, was there a conventional meaning from the context? And if so, what was that conventional meaning? Next step, look at the broader societal debate over the Constitution. Look at the debates in the newspapers, like the Federalist Papers. Look at the debates in the state ratification conventions. And the data set is actually huge. It's actually humanly almost unmanageable. Newspaper accounts, sermons, diaries, letters. because the goal that we're looking for isn't what James Madison thought the word religion meant, who introduced the First Amendment. We're looking for the public meaning of the text at the time, and all of these are evidence of what that might be. Lastly, we look at the background cultural, philosophical, and religious context. We say, in a society like the United States in 1791, given their religious commitments and cultural commitments and philosophical commitments, what would they understand the word religion to mean? In a series of, I think, 3 articles over the last, I guess it's been 15 years now, I've used different tools to try and uncover the original meaning of the word religion. And my conclusion was that the meaning of religion in 1791, which was publicly available, are belief systems with belief in a deity, with duties in this life, and a future state of rewards and punishments. So that's a very brief summary of how you do originalism. But you might reasonably respond, ours is a common law system in which stare decisis plays a fundamental role. And there doesn't seem to be any place in originalism, from my description, for stare decisis to play a role. And in fact, many critics have reasonably argued that originalism's commitment to following the original meaning would mean that adopting originalism would cause dramatic instability and harm reliance interests. And so think, for example, of the case of the legal tender cases. Those were a series of cases in 1871 where the Supreme Court made legal the paper money that many of us have in our pockets. And overruling that decision would cause dramatic instability. And so adopting originalism leads to the specter of that kind of dramatic instability. And confirming critics' worst fears, this is Justice Thomas. Now, I picked this picture because I think he's metaphorically saying stop to stare decisis. Because recently in his concurrence in Gamble versus U.S., Justice Thomas argued that there's very little space in originalism for stare decisis. What I argue on the contrary is that in originalism's promise is that originalism actually privileges precedent, because the Constitution itself commands federal judges to give significant respect to precedent. So what I argue in my book and in some previous articles is that the public meaning of judicial power in 1789 required federal judges to give significant respect to precedent. And so as this simplified originalist decision tree makes clear, the very first move that an originalist judge should make isn't to look for the original meaning of the Constitution, it's to see, is there precedent? And then the judge decides, is this originalist precedent, in which case the judge has to follow it. And then if it's not originalist precedent, I give an argument, an analysis that the judge should go through to decide whether and to what extent to follow that non-originalist precedent. But the key point is that central to originalism is a strong commitment to stare decisis. So if you followed me up to now, you might see, I can see how you can do originalism, and you might see how originalism can work given our common law system, but your next question should probably be, why should we do originalism? And over the last 25 years, originalist scholars have offered a variety of arguments as to why originalism is the best way, the right way to interpret our Constitution. And I'm just listing, for purposes of time here, 3 common arguments that have been given by originalists up to this point. And I'm happy to explain them more fully in the question and comment period. But what these scholars are trying to argue, and what I'm going to argue shortly, is that it's a response to questions like this. Why do I have to be an originalist if originalism leads to this bad result or that bad case? Or why can't the original meaning just be one factor among many that judges should take into account? What these scholars argue, and what I'm going to argue, is that overall and systemically, originalism leads to the most popular sovereignty, the best consequences, or the most protection of natural rights. Or what I'm going to argue next, the best conditions for Americans to flourish in the United States today. So my second move this afternoon is to summarize the natural law tradition. This is a huge topic. I'm providing the barest of summaries of it. And in my experience, frankly, many people, I think, have a caricature of the natural law tradition. So if what I say sounds different than what you've heard before, I wouldn't be surprised by that. The natural law tradition has its roots in Greek and Roman thought. It was carried through the Middle Ages, people like St. Thomas Aquinas. And today, prominent proponents are at Oxford, John Finnis, and at Princeton, Robert P. George, as examples in the Anglo-American world. The natural law tradition is incredibly rich. The natural law tradition has 2 key components. One is natural law, and the second is virtue ethics. And I think the best way to think of these is as 2 mechanisms, 2 tools that we as humans have to find happiness, to find human flourishing. So the goal of both natural law and virtue ethics is to help us achieve our fullest selves. And these 2 mechanisms exist because of our human nature, the way that we're made. They're natural to us as human beings, regardless of our gender, or our race, or our class, or our culture, or religion, or the time period in which we live. Natural law helps us achieve happiness by giving us rules external to ourselves And virtue ethics helps us achieve happiness by giving us the right type of character to be able to follow the natural law and to pursue good. For the sake of time constraints, I'm going to focus on the natural law component for the most part this afternoon. So first, the natural law component. Natural law is a collection of laws, of rules, of principles that guide us to happiness. They tell us what actions are going to make us happy and what actions are going to make us unhappy. And these laws are natural because they apply to us as human beings with a human body and rational soul. So different natural laws would apply to us if we were different types of beings. For example, we have bodies that need rest, and so one of the natural law's injunctions is to value leisure time. And these natural laws are laws because they instruct us, they direct us to achieve certain ends, and we call these ends basic human goods, and to shun other things, things that will harm these basic human goods. The basic human goods are the things that make life worth living, like life and leisure and friendship or knowledge. So one of the reasons why many of you came to law school is knowledge, or one of the reasons why you might take Professor Sanders' class on constitutional interpretation is the knowledge that you're going to gain in that class. And so stepping back for a minute, basic human goods are the answers that you give yourself when you say, why am I doing this? Why am I taking this class? Why am I going to law school? And knowledge is an answer. Basically, the basic human good of knowledge is an answer to that question. And when you think about the basic human goods, I think asking parents what they want for their children is an especially easy way to identify these. When you ask a parent, what do you want for your child? Do you want life and leisure and friendship and knowledge? And those are the things that parents want for their kids when their children grow up. Now compare that to money. Money is not a basic human good because it's instrumental to other truly fundamental things. So one of the things that was wrong with Ebenezer Scrooge here on the right was that he wanted money for its own sake, and not for friendship with his nephew Fred, and not for assisting his employee son, Tiny Tim, in the basic human good of health. And one of the things that was right with George Bailey was that he spent his entire life seeking the good of friendship in family and community, even at the expense of material success. The second key component of the natural law tradition is virtue ethics. Now, virtue ethics, as I said, gives us internal guidance. It tells us the kind of character we need to be able to pursue our own happiness. Because of time constraints, I won't go into detail into this. I'll just focus on one virtue, temperance, because I think it's easy for us to understand. Temperance is the virtue of using material things in a reasonable manner. If many of you, like me, probably have the experience of a family member or a friend who drinks to excess. And this intemperance prevents that friend or that family member from experiencing the other basic human goods, like friendship or like health, and diminishes that person's happiness. So in sum, I've described the natural law tradition as having two key components. One is natural law, and the other is virtue ethics. Both are aimed at facilitating human happiness. What I'm going to do next is I'm going to argue that originalism is the theory of interpretation that follows from the natural law tradition. So my third move this afternoon is to combine my previous two claims and argue that the natural law account of our Constitution leads to originalism. My core claim is that originalism follows from the tradition because it best facilitates the United States' common good and individual human flourishing. And the way I'm going to approach this is in a two-step manner. First, I'm going to talk about law generally, and then apply those lessons to the Constitution in particular. So first, thinking back about law generally. Why do we have positive law? What's its function? So my argument proceeds in four parts. First, we talked about human flourishing. What is human flourishing? When we live full, happy human lives. And my argument here is that positive law is a necessary component to human flourishing. Positive law should encourage human flourishing. A society is better to the extent to which it enables its members to flourish. And positive law is a useful tool, although not the only tool, to achieve that end. So think about the basic human good of knowledge. One of the reasons why it's good for states to have access to education for their children and for adults in college and law school, and to not have unreasonable barriers, like barriers based on race or gender, is because it provides greater access to the basic human good of knowledge. But human flourishing can only occur if positive law and legal authority overcome what are called coordination problems. Coordination problems are the obstacles to the social cooperation necessary to achieving human flourishing. So step back and think of all the good things that we do that would not be possible without significant social cooperation. And the example that I like to use is driving, because most of us drive on the highways regularly. And if you're like me, I don't think for a second about the cooperation that this involves. But if you're like me, and let's say that maybe you've traveled to another country, especially one where you don't speak the language, and think about trying to drive on the highways there, and how hard it is to actually cooperate with the other people on the highways because you're not sure what the rules of the road are. So you're not sure, it's making it hard for you to cooperate. And the complexity of the coordination problem challenges only increases as the importance of the basic human good at issue itself increases in importance. So thinking about educating a community's children is enormously challenging because of the importance of the good. Third, positive law is an essential tool to overcome these coordination problems. And positive law does so through authoritative, prudential, social ordering decisions. Let's focus on highway regulations. Every state in the Union and every society of any complexity has an authoritative person or institution that identifies who's going to make the rules of the road. And in Indiana, there's a Department of Transportation, there's the state legislature, and they do the things like speed limits, and what side of the road you're going to drive on, safety regulations, environmental regulations, and on and on. Second, these decisions are prudential. There's not one right answer to how a community should drive on the highways. Speed limit can reasonably vary. The side of the road you drive on can reasonably vary. Environmental regulations can reasonably vary. And so all of these judgments are, all things considered, judgments under the circumstances. Third, these decisions are coordinating because the decision coordinates the members of society towards an end, which is mutual cooperative use of the highway regulations. These decisions, because they overcome coordination problems, permit individual members of a society to pursue their own individual goods. Fourth, and here's the key point, every member of a society is obliged to follow the legal system's authoritative decisions because they overcome coordination problems and permit all the members of that community to pursue their own goods, to flourish. A practically reasonable person will see that the legal system is a necessary component of his own and his fellow citizens' flourishing, that the legal system itself provides a sound reason for following the legal system's coordination, and will not undermine the legal system's directives to support that legal system, and in other words, will follow it. So think back to our aggressive driver. The aggressive driver who pulls onto the shoulder, speeds past them and everybody else. My argument today is that that citizen is not following law's coordination and is not being practically reasonable, and in doing so hurts both himself and his fellow citizens. This aggressive driver hurt himself. He directly harmed himself in the participation of some of the basic human goods: practical reasonableness, justice, civic friendship. Let me just focus on civic friendship. If you're like me and you said something under your breath as that person drove by, something negative, that was your judgment that that person was acting in a negative way. And my claim today is actually they were acting in a negative way, and your judgment was right when it applied that judgment to that person. And the aggressive driver is also harming his fellow citizens. So what's your second inclination when you see the aggressive driver drive past you? If you're like me, it's, I want to get on that shoulder too, and I want to start speeding past. And what happens is, if one person starts to undermine the coordination, and there's no consequences because of it, then other people will undermine the coordination, and then you have a vicious cycle that undermines the rule of law in that circumstance. A necessary condition for the efficacy of law's authoritative decisions is that citizens know what the decisions are. The legal authority must effectively communicate his or her decisions to the people who are being regulated. And the way our legal system does that is through statutes, through regulations, and through, when it comes to the highway system, through signs. The normal means that our system uses are those legal texts. And so my account of legal interpretation is to try and identify what the communication was from the legal authority. What was the legal authority trying to do? How was the legal authority trying to overcome the coordination problem, so that way everybody can be coordinated? And that's an originalist view of legal interpretation. So how about the Constitution? Let me apply this account to our Constitution. The Constitution, I argue, is American society's response to basic coordination problems. How many branches of government should we have? What powers should Congress have? How long should the president's term be? There's not one right answer to any of those fundamental questions, and many more, but there has to be an answer to all of those fundamental questions to have a properly functioning, coordinating legal system. First, the Constitution was adopted by our society through means recognized as authoritative. The reason why the document in the National Archives is our Constitution isn't because it's the most normatively attractive document. It's not. It's not because it's the most beautifully written document, although it is kind of nicely written. It's because it went through the process that Americans in 1789 and Americans today recognize as being the sole process that identified our authoritative Constitution. Second, the Constitution's decisions are the result of prudential judgments. So think back to the president's term of office. There's not one right answer to that. the framers and ratifiers had experienced post-revolutionary governors with one-year terms, and that didn't work out very well because the legislatures overawed the governors. On the other hand, we had experience with long-term executive officers, the king, and that didn't work out very well. So the 4-year term was an all things considered judgment of long enough to give the president some independence, but not too long to make the president too independent. Third, the Constitution coordinated Americans and continues to coordinate Americans today. The Interstate Commerce Clause authorized Congress to eliminate or preserve, up to Congress, state interstate trade barriers, and that coordination worked in 1789 and continues to work today. Here's where originalism comes in. Originalism is necessary to understand the Constitution's authoritative, prudential, social ordering decisions. For Americans in 1787 and for us today to understand the original meaning allows us to overcome the coordination problems. So let's take Article 4, Section 4, which authorizes the federal government to intervene into states in cases of domestic violence. If we were using a conventional meaning today, domestic violence would have a connotation of spousal abuse. And what that would mean is the federal government would have authority, given the prevalence of spousal abuse in American society, to intervene into state affairs on an almost unlimited basis. But that isn't the coordination point that was adopted by the framers and ratifiers. They had a prudential judgment. On the one hand, our legal system loves federalism. On the other hand, federalism isn't worth anything if the state is being subject to domestic violence, having the connotation of insurrection or rebellion. So the domestic violence clause was an all things considered prudential balance of federalism is good, but we don't want to make federalism kind of a shibboleth that prevents us from seeing when states are actually being subverted internally. So just like our aggressive driver that we mentioned earlier, judges have sound reasons to follow the original meaning and should not substitute other meanings. So let's say that we had a judge who said that he thinks we can forget about the 18th century, much of the text. We ask with respect to contemporary constitutional issues, we ask, what is a sensible response? And there are two reasons why that judge is harming both himself and his fellow citizens. So first, the judge is not using the original meaning, is harming himself in his own capacity to flourish. And in the book I give a number of examples of that. Let me just focus on one. The virtue of justice is lawfulness. So when you think of judges, the paradigm virtue of what judges do is they judge the cases before them according to the law. And the law isn't something that's made up in the process of the case or made up after the case. The law is something that's pre-existing. The parties are coming to the judge saying we have a dispute that the law settles. They disagree about what the settlement is, and they're asking the judge to tell them what the law says in that case. So think, for example, for those of you who've had constitutional law and you've covered the Contracts Clause, Home Building and Loan versus Blaisdell. It was the 1934 case where the Supreme Court faced a Minnesota law that had undermined a contract, a mortgage contract. And the two parties came to the case, and under current law, which I think is undisputed, under then current law, the party wishing to retain the contract should have, under the Contracts Clause, had that contract retained. But as you know, if you've read the case, the Supreme Court created a new non-originalist interpretation in that case and then applied that new law, that new interpretation, to the parties before it. That's not the virtue of justice's lawfulness because the parties were going to the judges for an answer under then existing law. Second, the judge who doesn't follow the original meaning doesn't harm just himself, but also harms the ability of the legal system to properly function. So did anybody here watch any of the Kavanaugh hearings? So I was on sabbatical and I should have been doing more writing, but the Kavanaugh hearings were it was like a train wreck, I thought. I don't know what your guys' thought was. It was like a train wreck and I couldn't take my eyes off it. It was terrible. And there are many reasons why it was a train wreck. One reason why it was a train wreck was because both sides in the debate saw Justice Kavanaugh not as somebody who was going to exercise the virtue as justice's lawfulness, but saw Justice then nominee Kavanaugh as somebody who was going to, through the guise of interpretation, identify his interpretations on public policy issues like gun rights or abortion or the size of government, and that's what they were fighting about. That's what the passion and vitriol was in the Kavanaugh hearings. And just imagine, so let's say that, God forbid, Justice Ginsburg retires or passes away, and then we have to have a confirmation hearing now, and imagine, given the Kavanaugh hearings, how truly devastating the hearings to replace Justice Ginsburg would be. So what I've argued this afternoon so far is that originalism, by identifying the Constitution's solutions to coordination problems, best facilitates human flourishing and is therefore the most normatively attractive theory of interpretation. Following originalism is necessary because it effectuates our society's authoritatively established legal norms and their solution to our coordination problems, which enables each of us to pursue our own individual goods. My last remark is going to be about virtue ethics. And I mentioned before about virtue ethics as one of the key components of the natural law tradition. And I'm not going to go into detail all the ways that the judicial virtues can help judges be the best judges that they can be. So I'm just going to mention two examples. One of them deals with Justice Thomas and the virtue of theoretical wisdom. So theoretical or legal wisdom is the judge having the firepower, the brain power, to be able to master an area of law, describe it accurately, and then apply it elegantly in a case. One of my favorite examples, Professor Saunders might have the same view, is Justice Thomas's concurrence in Lopez. It was the first kind of originalist Commerce Clause opinion, and I love teaching it, but I also hate teaching it. So I love teaching it, and I actually do spend a fair amount of time because it's this elegant and articulate summary of his view of what the original meaning is. But I hate teaching it because it's like so elegant and so intricate that it takes a lot of time to do it. And I think that's Justice Thomas exemplifying the virtue of theoretical wisdom. On the flip side, Justice Scalia, who is one of my favorite justices for many reasons, I think Justice Scalia displayed the virtue of judicial intemperance in Obergefell versus Hodges. So judicial temperance is maintaining a judicial demeanor, to not commenting on the persons or subjects before the court, but commenting on the law in a judicial manner. And if you remember, if you've covered Obergefell versus Hodges, Justice Scalia in dissent characterized the majority as, if he was asked to join it, he said, quote, "I would hide my head in a bag," which I'm confident was his view about what he would do if that was true, but I think that was an intemperate statement for him to make. And so that would be an example of him not exemplifying the judicial virtues. So I made three moves this afternoon. First, I described originalism, what it is, how you do it, and why you would do it. Second, I described the natural law tradition. And third, I argued that the natural law tradition leads to an originalist account of our Constitution. And I'm looking forward to Professor Sanders' comments and yours as well. Thank you so much.
Thanks. Lee is actually one of the people in the legal academy that, other than my own law school professors, that I think I've known, or at least known of, the longest. You may remember the story. I was an articles editor in the Michigan Law Review, and I was there late one night, and I was looking at the submission we had gotten from this young associate at Jenner and Block in Chicago, who clearly, in addition to having to bill over 2,000 hours a year, was burning the midnight oil writing, very thoughtful, in-depth legal and philosophical articles, and that was Lee. And I think I even sent you an email at that time. I'm a little older than Lee because I was a little older when I went to law school, but I was an articles editor. He was just a couple of years out of law school, and already, just showing how serious and committed he was to scholarship. And I don't remember if the articles were on originalism per se, probably. And the other way I've known Lee is almost every year the two of us go to the same conference at Loyola in Chicago. It's a constitutional law conference, and most years Lee is there presenting. I think for a while he was presenting early pieces of this book, and is always presenting interesting work on originalism. And I have to say, since I taught a seminar on constitutional interpretation last semester, with a few people here in the audience were part of, I now feel that, having done a sort of deeper dive into originalism as well as other fields, I feel like I can now make greater sense of a lot of the things I've heard Lee talking about at this conference and Lee's book. I assigned part of Lee's book to the class because it provides such a good overview, an introduction to the various strands of originalism. But that's, I guess, part of what I want to talk about is what do we mean when we're talking about originalism? This is not intended to be a sort of all-purpose response to Lee's book. I was just sort of making notes on the fly to try to respond or provide a couple of comments on points he has made here. One of the most frequent criticisms of originalism is that it is too often indeterminate. The historical sources don't give us the guidance that we need. So, starting with the example of what is religion, what was the original public meaning of religion at the time, my sense is that that's an easier question to answer than the controversies that occupy us today, which is what constitutes an exercise of religion, what is protected as exercise of religion, what is not, what constitutes an establishment of religion, and what does not. Justice Thomas, I think, would say that the religion clauses of the First Amendment were intended to protect state establishments of religion against federal interference. That is certainly not the mainstream understanding, and my sense is many originalists today would shrink from that extreme in a view of the original meaning of the Establishment Clause. Lee described, I think, very accurately, originalism as a dynamic theory. And so one of the things I would sort of most like to know, or one of the things that I think remains unaddressed in the presentation, is which version of originalism does Lee find most appealing? So again, people who were in my seminar know that kind of the key dividing line, I think, is, okay, there's original public meaning. What was the meaning of this word or this command at the time it was written? But that can be different than what was the original intended application. In other words, under what circumstances did the framers imagine circumstances under which we would confront today, where we would have to figure out what their words and what the original public understanding meant? Originalism ranges from the early versions of people like Raoul Berger and Robert Bork, who basically held that, if the framers, it's the application at the time that the framers could have imagined that still is relevant today. So if the framers of the 14th Amendment couldn't possibly have intended or understood the 14th Amendment to protect something like abortion or gay sex, then it is just off the table today. The other view, the sort of more modern view, the sort of new originalism or the new originalism, is no, we still care about what the original public meaning was, but what we're looking for there is the value or the principle. Where the 14th Amendment is pertinent, the value or principle of liberty or of equality, and what does that mean today? How can we take the anti-subordination theory and principle and value of the Fourth Amendment and properly apply it to analyze laws restricting abortion or laws restricting gay marriage or laws imposing disabilities on the basis of race? And so originalism ranges from that very narrow original intended application view toward a much more capacious view that's been put forth by scholars like Will Bode, and my sense is that Lee might be a little closer to that, because Will Bode and the sort of newest originalists say because judges from the earliest times of our nation's history used precedent and cared about precedent and stare decisis. Therefore, as long as you're following precedent and stare decisis, you're doing originalism. And there are people sort of in the middle, like Randy Barnett, who have theorized what we do when original public meaning runs out, when it's simply indeterminate. My sense is from the flowchart, Lee's answer is defer to the elected branches. There are certainly originalists in good standing who think that no, judges can reason their way to, even if they're moving in sort of uncharted territory, they can somehow apply originalist values and principles to come to proper answers about situations where the text or the original public meaning itself is indeterminate. So I have come to think that in order to properly evaluate someone's originalism, you need to know a little bit more about how narrow or broad a conception of originalism are they talking about. This is one reason, I think, why originalism retains such an interest in the academy, and there are no shortage of speakers and conferences and books about it, because it is such a big tent and there are such interesting debates among originalists, which Lee actually does a wonderful job in the book at portraying in a sort of honest broker way in the introduction, the early part of the book. It's a tour of what interesting but also very diverse intellectual territory originalism is. And just a couple of final thoughts more specifically. The emphasis on the common good and human flourishing, I think, is where Lee ties this into the natural law tradition and even Aristotelian philosophy and so forth. But I would again say the devil is in the details, and usually what we're arguing about in constitutional discourse is not sort of about life and leisure and friendship, it's about guns. And what is the meaning of the Second Amendment? Is it essential to the common good and human flourishing for Americans to have an individual right to keep and bear arms? Now, there are certainly people who would argue in favor of the idea, but just as powerful, I think, was Justice Stevens's argument in McDonald versus City of Chicago that said we need to think about this in substantive due process terms. It's necessary to think about what role do guns play vis-a-vis the common good and human flourishing today in our society as we understand it. As Justice Stevens says, guns have a fundamentally ambivalent relationship to the idea of liberty. Another great dividing line between progressives and conservatives is the Constitution understood to enact a colorblind understanding of racial equal protection. That is, whether the advantage goes to whether the law advantages or disadvantages whites or African Americans, whether it's racism or whether it's affirmative action, it all gets strict scrutiny because colorblindness is an important principle. There's a good argument to be made that the 14th Amendment instead should be understood to enact an anti-subordination principle, and that laws that are intended to to address a history of racial disadvantage and racial discrimination, such as affirmative action, should get less strict scrutiny, that there's a difference between a do not enter sign and a welcome mat, as again Justice Stevens, I think, put it in one of his opinions on affirmative action. That's a dividing line. So I'm not sure how, whose common good and whose idea of human flourishing are we talking about? You can make, I think, very defensible and very honest arguments for both visions of constitutional equal protection, color blindness and anti-subordination, but to simply say we need to serve the common good and human flourishing, I think is not to tell us how we would specifically answer that question. And of course you could say the same thing, I think, about gay marriage. If you are a very traditional, original intended application of originalism, a version of originalist, you would think it's absurd that the Constitution has anything to say about gay marriage, that the 14th Amendment has any meaning there, but very respectable originalists like Stephen Calabresi have taken the approach that I described earlier and said, no, the appropriate argument is that the 14th Amendment enacts an anti-caste, anti-class legislation, anti-subordination principle. That's the original meaning of the 14th Amendment. And now we can apply it in this contemporary context that we have the empirical understanding and the social and cultural knowledge to fully grasp that the framers of the 14th Amendment would not have. We can do the original meaning of the 14th Amendment and still be consistent with the idea of gender and sexual equality. That's certainly not to say that Obergefell, as the court gave it to us, is any kind of originalist decision. It is to say that originalists vigorously disagree about whether the right to reproductive choice and the right to gay marriage and the right against sodomy laws, what is the appropriate original understanding there. Finally, and this is just sort of maybe picking out one passage of Lee's book that gave me a little bit of pause, is I'm wondering about the dead hand problem here. Again, if you are a more traditional sort of originalism version 1 originalist, where you are not only looking for the original public meaning, but also we're confining it to the original intended application, there's a passage of Lee's book that I picked up on that says, the framers and ratifiers had reasons to write and authorize the Constitution. Those same reasons explain and justify the Constitution's legal instructions to Americans. And by that, I think Lee means Americans today. And those legal instructions are communicated via the Constitution's original meaning. Originalism treats the Constitution as an act of reasoned lawmaking and tries to understand its product as rational communication. I think this ties into Lee's idea that we need positive law, we need rules of the road, we need legal authority, we need positivism in order to organize society and coordinate our society legally. But that doesn't necessarily answer the problem of the dead hand. Why is a decision that is done in the living Constitution or the common law Constitution model, one of the non-originalist models, why should we assume that is any less positivistic, any less of a command that ought to be honored and obeyed by our society? Lee's, and this will be my final point, an example that Lee gives about sort of the alternative to originalism. He describes judges deciding, what is the sensible response to this problem? What's the problem that makes sense today? I think that's probably not fair to living constitutionalism or common law constitutionalism as I understand it, which does care about precedent, which of course says text is the starting point. If the text speaks to something, precedent is important. I think that what Lee is talking about is more descriptive of something like Ronald Dworkin's work, which sort of says, judges should come to the morally correct decision, or even someone like Judge Posner, who was on the Seventh Circuit in Chicago, who was sort of most interested in pragmatism. Don't bother me with a lot of doctrine. Let's just figure out what makes sense in this particular situation. So I think that that alternatives to originalism can't be quite as easily dismissed as perhaps the slides indicated, although I think that's not what Lee does in the book. Lee has responses to those in the book. But mostly I'm trying to say I think this is a valuable introduction to principles of originalism, and Lee's specific contribution here is to tie it into the natural law tradition. I'm just encouraging you and encouraging him that we always need to think about the really difficult cases and questions where these principles have to come into play and in order to know whether originalism is truly helpful or not to us as legal guidance. So I hope that was quick, that was off the cuff. I hope that made a certain amount of sense. And I don't know if Lee wants to respond to any of that, and I hope we still have some time for questions.
Are we done at 1?
Yes, if you'd like to respond, please.
Maybe I'll just take 5 minutes. So Steve, I thank you so much for these 4 different comments. And I think there's like 2 different categories of constructive criticism that you identified. One is kind of operative. How does one do originalism? So a level of indeterminacy. What's the best version of originalism? And the second is, how does my natural law argument actually justify originalism in the details of the case? In situations where many of us are going to reasonably disagree about what the proper outcome ethically would be in that case, right? And so I'll just say a couple of things. So on the first part, when it comes to how originalists answer cases, there's a lot of debate out there. What I try to give is an argument that the original meaning of the Constitution has enough resources to actually answer most cases. And so what that means is that the Constitution contains what I call rules of interpretation, rules of thumb. And one of them, for example, which I think all of us actually implicitly agree with, this is why I think it's a powerful argument, is the 51-49 rule. If you're a judge and you have 2 parties coming before you and you have to make a decision about whose interpretation is more likely, here's your job, whose interpretation is more likely the correct interpretation of the Constitution, and let's say it's a close call. Boy, oh boy, that's some good argument, that's some good argument. What do judges do? They have to make a decision. And my argument is that implicitly our legal system has a 51-49 rule. The judge should go with the person who has 51% of the weight of the arguments on their side. And so I think that's one of many rules that I articulate that tries to decrease the area of indeterminacy. In other words, it's saying that there are hard cases, but I think there are mechanisms our legal system has created to answer those cases. On the second point, I intentionally, and so I'm glad you highlighted this point, Steve, I intentionally avoid getting into the details of almost all the cases that you're covering in constitutional law, with 2 exceptions. I kind of have test cases with Brown and Rowe to kind of give people a feel for how this process would work out. And the reason why I do that is because my goal isn't to say that because the majority in Heller, which said there's an individual right to keep and bear arms, is right, therefore that supports the common good, and therefore originalism is right. And it's not to say the opposite either. My goal is to step back and say, looking at our legal system overall, looking externally at our Constitution, what justifies following the Constitution's command, and then given that justification, what meaning should we attribute to the Constitution? And the way I think about this is servitude law, which may sound counterintuitive. How many people here have studied servitude so far? Servitudes is easements, row covenants, equitable servitudes. So only one person, a couple people? Okay. That's not usually what the answer is. So if you studied servitude law, American servitude law, I think you should come away from that process thinking, if you were designing that system, you wouldn't design it that way, right? Nobody ever comes out of studying servitude law saying, this is a great way to do it. And the reason why that is because of law's characteristics. We don't, when it comes to saying whether servitude law is the law, we don't do what Steve was saying, which is this particular case or is this particular doctrine just, and then feed that back into whether servitude law overall is something we follow. What my argument is that the purpose of servitude law, imperfectly effectuated in American law currently, is to allow neighbors to live together in ways like with driveways and other kinds of relationships, and that secures the common good for those neighbors. And so I allied the concrete details of the doctrines there and give a justification for positive law generally or servitude law in particular, or my claim is the Constitution in particular. So I've very briefly answered. I haven't answered them, but I've given you kind of a thumbnail of what my answers would be if we had more time. So I'm looking forward to questions.
Thank you. This is for Professor Strang. How do you think the use of corpus linguistic analysis will transform, if at all, the application of originalism in individual cases and controversies? I know Justice Tom Lee on the Utah Supreme Court uses this method. Do you think it has a transformative role for originalists moving forward and pinpointing the more empirically precise original public meaning?
Okay, so let me make sure everybody's on the same page. So corpus linguistics is using computers to study large bodies of documents to find patterns, word patterns and regularities that then have connotations of meaning regularities as well. And the reason why originalists are interested in that is one of Steve's constructive criticisms, which is that is it the case that that we know we can access what the original meaning is, or is it the case that it often doesn't give us an answer? It's indeterminate. And corpus linguistics promises to be an additional tool, although I don't think it'll ever be the tool, but an additional tool to help originalists supplement, criticize existing views on what the original meaning is. And so I used corpus linguistics. So in an article I wrote about 15 years ago, I used what we would call Originalism 1.0 tools of research, which basically meant I was down in the library for months and I photocopied thousands of documents where the word religion was used, and then using my own analytical capabilities, tried to identify the conventional meaning and then to articulate what that was in an article. And then more recently, 2 years ago, I used corpus linguistics. There's a large body of documents called COFIA, the Corpus of Founding Era America, which includes, I forget the number, it's like hundreds of millions of documents. And I searched for every time the word religion appeared and used the corpus linguistics techniques to help me identify what the conventional meaning of the word religion was during that period. And just so you know, it actually supports something that Steve said. It supported my claim about one facet of religion, that religion was a theistic conception in 1791, but it also not undermines, not the right word, but it called into question the determinacy of the other items that I had identified as the original meaning. So what that did was, it's what good scholarship does, right? It's confirming some things and then also saying, got to do some more work on some other things as well. So I think it's a tool, it's not a holy grail.
I think maybe I'm next. So thank you for this very elegant, very clear, very good-natured presentation. You don't often hear people talk about these subjects in such an amiable way. But I'm grateful to Steve for the same thing. I have not yet had a chance to read the book. I will now. And so I may be oversimplifying your claim here. And so let me lay it out as I see it. Very often, natural laws take it as a warrant for departing from originalism, because ultimately you're not answerable to James Madison or the founding generation at all. You're answerable to Aristotle or Aquinas or God. And so therefore we ought to construe it in a really different way. And I take it that your response to that, in a really interesting way that you tie originalism with natural law, is the notion of coordination enhancing mechanisms. So I have that right? Okay, good. So the claim, I take it then, is that originalism offers the best chance for this kind of coordination enhancing, which will lead to greater human flourishing. Is that correct?
It's close. I would say it's the best chance of identifying the authoritative coordination.
Okay. So then so I take it then that's an empirical claim, is that right, about American culture at this time?
Meaning today?
Yeah.
Yes.
Okay.
Yes.
So,
Yes.
all right. So then it depends on an empirical claim, number one, that originalism is authoritative. Is that right? That Americans broadly regard it as authoritative?
No, my claim is that Americans would regard the written Constitution and its coordination as authoritative, and that originalism is the way to ascertain and effectuate that.
Okay. Well, now all this is, though, being driven through the idea of coordination enhancement, right? Okay. So the claim is that the Constitution is authoritative. I think people would agree with that. But do you have to make, and what I'm suggesting is maybe you have to make the additional claim that originalism is the best coordination enhancing way of interpreting the Constitution? Because it's not the only way. And if it could be shown that there's another way that actually generates greater coordination, then wouldn't your natural law argument lead you to depart from originalism, unless you can make the empirical claim that, in fact, it's going to lead to greater coordination enhancement?
I appreciate that question. It's one that is, so I do not think I need to make that additional claim, and it's because my claim is that the current practice identifies the written Constitution as our Constitution, that that Constitution what's the right word? As premises of the empirical claim that our written Constitution is our Constitution, is the situation out of which it arose. And so my claim is that the process that gave us the Constitution is, and to understand that process and the authority of the humans who framed it, the authority of the humans who ratified it, and then the humans who later have followed it, that the original meaning is the only conception of meaning that can describe that as a reasonable process. And here's what I mean. If you're James Madison and you see a problem with the mistreatment of religion by the federal government, or potential mistreatment of religion by the federal government, that the meaning that allowed him to identify the coordination problem, overcome the coordination problem, have the ratifiers understand it, and adopt that response to the coordination problem, and then for American officers to follow it, the original meaning is the only one that makes sense of all of those phenomena. So not the best, but the one that fits the best. Not the best normatively, but the one that fits the best. Maybe that's the right description. I don't know. Maybe that's the right label. That's a great question. I appreciate that. It's something that I'm still actually working through to make it a more articulate way to explain my claim.
Yeah, and I can see that we're just about to answer. If I could just throw in really quickly.
I won't cut you off. Just you're the last question.
Okay,
so.
thank you. So I understand. I think there is an interesting analytical question about whether it does make the best sense of these American commitments. Because, of course, I think an awful lot of Americans would say, I am committed to the Constitution, but not to this way of understanding it. And if the goal, therefore, is coordination, it may be that a more pluralist understanding of interpretation would bring more people in terms of a coordination scheme. I also would wonder, and I'm just going to pose the question, either you'll have time to answer it or you won't. There is this question, if the natural law part of this is being driven through the coordination part of it, there's a question about which interpretive method is likely to yield the most consistent results, regardless of the interpreter, right? And so this goes back to Steve's point, which is that originalism can be used in a bunch of different directions. Because I take it that if the goal is coordination enhancement, then your 51 to 49 rule is not sufficient. What we're looking for is something like 95 to 5, right? Because we want everybody to believe that these determinations given by the Supreme Court are unambiguously the right determinations, and therefore we're all going to coordinate our behavior on this. I just got finished teaching the Nixon tapes case, in which if you didn't have unanimity, if we had a 5-4 split, people might not be coordinating their behavior as well around this interpretation. And I do understand that there are originalists, and I understand you have a rich theory of originalism that suggests that if it's sufficiently rich and varied, if the number of tools are sufficiently rich and varied, we're all going to come out the same way, right? And that therefore the problem is that originalism is not always done the right way. But if the claim here is coordination enhancement, maybe the question isn't really so much how it could be done in theory, but how it's actually done. Does that make sense?
Sure. Yeah, and I appreciate those very thoughtful comments.
And I appreciate everyone coming out today. Please join me in giving them a round of applause.